Hello everyone, I can see there's still some people joining, so I'm just going to give another 30 seconds and then we'll get going. Okay, I think we can start now. So thanks very much for joining us this morning for this webinar on the topic of enforcing the EU Habitats Directive in national courts. So I'm Anne Friel, I'm a lawyer in ClientEarth's environmental democracy team based in Brussels. And this is the latest in a series of webinars on access to justice in environmental matters that ClientEarth is delivering as part of a joint project with Justice and Environment that's funded by the EU's LIFE programme. So this webinar is a tale of two halves. In the first half, I'll take you through the EU legal framework on access to justice in environmental matters and how it applies in the context of the Habitats Directive. And then I'm going to hand you over to my colleague, Soledad Gallego, who is a wildlife lawyer in our Madrid office and who will give you the perspective of an experienced practitioner. And she'll be able to give you insights into how the legal framework that I'm going to talk about really applies in practice. So at the end, we'll leave some time for you all to ask questions. So I think the easiest way to do that is for you to type your question and then we will respond to it in orally. Okay, so let's get started. So as you can see, I've got quite a lot to get through, but I wanted to touch on all of these aspects of access to justice because each one is so important in its own right and presents its own problems depending on the jurisdiction that you're working in. However, time restrictions won't allow me to go into a lot of detail on all of these, so I just want to point out at the outset that we've published a legal guide on access to justice that covers all of these issues in a lot more detail, and you'll find the website, the web address to that at the end of this presentation. And of course, then there's the Commission's 2017 Notice on Access to Justice in Environmental Matters, which is also a really valuable resource if you want to read up on these issues in a lot more detail. So I'm going to cover kind of the main legal provisions that the Court of Justice of the EU relies on in providing access to justice to the public in environmental matters, and particularly in the context of the Habitats Directive and the main cases. Then we're going to look at what decisions can be challenged in order to enforce the Habitats Directive, who can bring these cases, so who has legal standing, the scope and standards of review that's required of national courts when they review decisions, the possibility for interim measures, and then remedies. So I'm not going to go through all of the provisions of the Habitats Directive, and that's not the kind of object of this webinar, but just to remind ourselves that the Habitats Directive is there to ensure the conservation of rare, threatened or endemic animals and plant species, as well as rare and characteristic habitats. And it does this by establishing an EU-wide Natura 2000 ecological network of protected sites. It establishes lists of protected species, and then it puts in place protective measures for both the habitats and the species. It's a very effective and very comprehensive directive, but what it really lacks is a specific provision on access to justice. And as we all know, the EU has not adopted a directive, a more kind of broad and general directive, which implements the provisions of the access to justice pillar of the Aarhus Convention. And therefore, because of these lack of specific provisions, the member states do have quite a lot of discretion in saying who can bring cases in their national courts and on what grounds. Fortunately, in a series of preliminary references, the Court of Justice of the EU has found that member states' discretion is limited by a number of legal provisions, which I've kind of listed here and which will come back into my presentation as we go along. So let's just have a quick look at them first. So first, the Court relies on the general EU law principles that can be found in the Treaty on the European Union. So Article 19 establishes that member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by union law. And the court generally reads this together with Article 4.3 of the treaty as well, which states that member states shall take appropriate measures to ensure fulfilment of the obligations arising out of the treaties and and the resulting acts. So, for example, the Habitats Directive. More recently, the court has relied on Article 47 of the Charter of Fundamental Rights, on which guarantees effective remedies. And this is obviously based on Articles 6 and 13 of the European Convention on Human Rights. And then finally, of course, we have the Aarhus Convention itself, which is an international treaty which was ratified by all of the EU's member states, as well as the EU itself in its own right. So its Article 9.2 guarantees access to justice for the public concerned to challenge decisions that have been subject to the public participation provisions in Article 6 of the Convention. So this is really very relevant to enforcing decisions that are subject to the appropriate assessment obligations in Article 6.3 of the Habitats Directive. We'll talk about that in more detail. And then there's Article 9.3, which guarantees access to justice for other acts that breach national or EU laws relating to the environment. And then there's also Article 9.4, which guarantees effective remedies and a whole lot of other things, which I probably won't have time to talk about, but we will talk about effective remedies. So the Court of Justice of the EU has provided national courts with a lot of guidance as to how these provisions have to be enforced in national courts. So, of course, there are many cases at EU level that interpret the obligations contained in the Habitats Directive. But since I will be focusing really on what the court has said on the access to justice, specifically, these are the main cases that I'm going to touch upon today, as well as some others. So time doesn't really allow me to go into too much detail regarding the facts and the background of these cases, but all of them are referenced within the presentation so that you can go back and read them at your leisure. So when we talk about enforcing the Habitats Directive in national courts, we have to presuppose that members of the public can find their way to the court in the first place. So this means that it must be possible to identify an act or omission of a public authority that can be challenged in the first place, and B, that the persons wishing to challenge the decision have the right to take the case to court. So in other words, that they have legal standing. So I'm first going to have a look at what decisions could possibly be challenged at national level. So the Court of Justice has held that it must be possible for individuals, including environmental protection organisations, which I'll probably refer to as NGOs, which I refer to as NGOs in the slides, to challenge decisions that breach provisions of the Habitats Directive that grant rights or are of direct concern to those persons. So the court has made it very clear that decisions relating to the appropriate assessment obligations in Article 6.3 must be open to challenge, and this is probably what makes up the bulk of the court's case law. So in this way, the public can protect their procedural rights to participate in such assessments, but they can also protect this as substantive rights in terms of the result to be achieved, in terms of protecting the integrity of conservation sites. Also, the court has said that derogations from the protective measures for certain species under Article 16 can be challenged as well. So it's probably no surprise that the case law is focused on these obligations, as they're probably the most kind of actionable obligations in the directive. However, other provisions certainly affect the rights and concerns of members of the public, meaning that decisions that breach these provisions should be open to challenge in national courts. So I've given some examples in the slide here that I won't go into in too much detail, but it's just important to note that that there are obligations. For example, Article 6.2 of the Habitats Directive, which obliges member states to take appropriate steps to avoid the deterioration of conservation sites. So it's important to note that sometimes these obligations are really difficult to enforce in national courts. So deterioration, for example, often happens just through simple neglect. And in some member states, you really have to identify a specific decision to challenge. And obviously, in the case of neglect, there isn't one. So this problem really highlights the very important role of the EU Commission in bringing infringement proceedings to enforce the directive, as well as the role of national environment agencies, and that their actions are really the other side of the enforcement coin and are just as essential, of course, to access to justice for environmental organisations and individuals. So this takes me on to who can go to court, so who has legal standing. So as I've said, without an access to justice provision in the Habitats Directive, member states do have quite a lot of discretion as to who can bring cases in accordance with the principle of procedural autonomy, which you'll hear a lot about in the remainder of the presentation. However, fortunately, that discretion is restricted by the provisions I've already talked about. So first, the court has stated that Article 288 of the Treaty on the Functioning of the European Union, which is all about kind of the binding nature of directives and the obligation to give effect to their provisions. This read in conjunction with Article 4 on mutual cooperation and Article 19 on effective judicial protection, that these provisions together guarantee that individuals and NGOs must have access to national courts to enforce the procedural and substantive rights bestowed on by EU environmental law. So then, for decisions affecting public participation rights, such as those in Article 6.3, which I've already spoken about, the court has applied Article 9.2 of the Convention, read together with Article 47 of the Charter of Fundamental Rights, to ensure that individuals can protect those rights. Similarly, in terms of challenging decisions that breach other provisions of the directive that are of direct concern to individuals, the court has relied on Article 9.3 of the Convention, again read together with Article 47 of the Charter on the right to an effective remedy. So let's look at these in slightly more detail. So many member states, in implementing Article 9.2 of the Aarhus Convention, they have said that the environmental protection organisations that fill specific criteria that are laid down in law have automatic standing to challenge decisions that are subject to public participation. So the fact that the court has recognised that Article 9.2 applies to appropriate assessment decisions means that these NGOs in general will find it easy to have standing to protect those public participation rights. At the moment, we don't know exactly how this applies to individuals, but we can probably think that those individuals that have the right to participate in the appropriate assessments will have standing as well. But these cases haven't come before the Court of Justice yet in terms of individuals' rights. So for the other, in terms of challenging other decisions that breach provisions of the Habitats Directive, the court has applied Article 9.3 with Article 47 of the Charter. to say that national procedural rules on standing must be interpreted in accordance with Article 9.3 of the Aarhus Convention and the right to an effective remedy. So those national rules that kind of bar access to a whole category of persons will not comply with these provisions. So the court has recognised the right of environmental protection agencies in its case law on this. And then, of course, in the later case of Protect, the court made it really clear that if a conform interpretation with Article 9.3 and Article 47 of the Charter is impossible, then the court of its own motion has to disapply those provisions of national procedural rules that are barring access to the court. So as I've said, the case law is really focused on environmental protection organisations up until now. And it's really still quite unclear as to how much access individuals will benefit from in terms of enforcing the Habitats Directive. So in other case law on access to justice and environmental matters, on air quality, for example, the court has taken a very broad approach to standing for individuals. That obviously, in the context of clean air, those individuals who live in specific zones that are highly polluted have access. And in very recent cases also that apply the Nitrates Directive and the Water Framework Directive, the court has focused on giving access to individuals who use a specific resource. So, for example, water was the resource in these cases. So that would imply that the court is ready to give quite a broad access to individuals. However, it's still very unclear in terms of the Habitats Directive, where there aren't really use rights for individuals in there. So we'll have to wait and see how that's going to progress. So when it comes to the scope of review, this can be quite a complicated area of case law of the Court of Justice, but for our purposes in terms of enforcing the Habitats Directive, it's very clear that it is possible to, you can base your challenge basically on rules of national law implementing the Habitats Directive, or in the absence of a correct implementation or of any implementation at all of the Habitats Directive or of the specific provision you want to enforce, then you can base your challenge directly on that provision if it has direct effect. So now we come to standard review. So that's the level of scrutiny that the national courts have to apply. And this can be quite a big problem in certain member states, including my own, where the courts tend to give quite a, they kind of give a lot of discretion to the public authority and how they implement environmental law, well, many areas of law. So the basic rule is that this is left to the member state's discretion, but again, according to the principle of procedural autonomy. But this discretion is again limited by two principles. First, the principle of equivalence. So it has to be, we have to make sure that the rules basically on standard review are no less favourable when implementing EU law than those governing similar domestic actions. And secondly, effectiveness. And this is probably the most important one for our purposes, and that these rules must not make it impossible in practice or excessively difficult to exercise rights conferred by EU law. Okay, I pressed the wrong button. So in practice, and when we're talking about the Habitats Directive, the Court of Justice actually required really quite a substantial review of public authorities' decisions. And for this, the Wadenzee case is very important. It makes it pretty clear that in the context of Article 6.3 in any case, national courts are required to assess whether the scientific evidence relied upon by the decision-making authority to authorise the plan or project in question leaves no reasonable scientific doubt as to the absence of adverse effects the integrity of a site. And this is very much an expression of the precautionary principle in Article 6.3 of the Habitats Directive. So next, injunctive relief. So we don't have very much guidance from the Court of Justice on this in the context of the Habitats Directive. We know that Article 9.4 guarantees injunctive relief, which is appropriate to ensure adequate and effective remedies.
Unmuted.
And we know that as a matter of EU law, injunctive relief must generally be available for EU law infringements, and conflicting procedural rules must be set aside, and this was decided way back in the Factutim case. But the actual details of these rules in terms of injunctive relief is very much left to the discretion of the member states, again subject to those principles of effectiveness and equivalence. So the Commission's own notice on access to justice and environmental matters indicates that it could be a good idea when you bring cases in national courts to refer to the Court of Justice's own case law, its case law on its own injunctive powers by analogy. And a good case to look at in that context would be the Commission versus Poland, which was on the logging in the Birdlife Forest, where the Court of Justice imposed injunctive measures, and again based itself on the precautionary principle. So that brings me on to remedies. So the basic rule in the Aarhus Convention is that the procedures shall provide adequate and effective remedies. And in EU law, the court has said that national courts must nullify the unlawful consequences of a breach of EU law. But again, the precise rules are left to the discretion of the member states, subject to the principles of effectiveness and equivalence. So let's have a closer look at what this means in the context of the Habitats Directive, and again focusing on Article 6. So in this case, C39914, this was looked at in quite a lot of detail by the Court of Justice in the situation where no appropriate assessment was carried out until after the construction works in the protected site had been completed, and the court said that actually even if the works have been completed, an appropriate assessment must still be carried out, and if it shows a risk of deterioration, then it's necessary to assess under Article 6.4 of the directive whether it should have been carried out for imperative reasons of public interest, and if yes, if there were available solutions while weighing the environmental consequences of maintaining or restricting the use of the works that have been carried out, including even closure or even demolition of them, on the one hand, against the important public interest that led to their construction on the other. And if there are no imperative reasons of public interest, then it's necessary to take all compensatory measures to ensure the overall coherence of the Natura site. Also, we now know in a recent case that exceptionally an activity may continue until that replacement assessment has been carried out following the completion of the works, or the extension of a permit, for example. But Article 6.2 does apply independently, so that if deterioration of the habitat prior to the new assessment, the authority must take appropriate steps in accordance with Article 6.2. So that brings me to the end of my presentation. So I'm going to hand over now to my colleague, Soledad, who will give you a very interesting insight into her practice in terms of enforcing the Habitats Directive. So, Soledad, are you there?
Yes, thank you. Thank you, Anne.
Okay, I'm moving on Soledad's slides. So just remember, just prompt me when you need me to move the slides.
Okay, thank you. Thank you. Good morning, everyone. Well, I'm going to explain one case from Spain about mine, an open pit mine from magnesites in Navarra in the north of Spain. First, I'm going to give an overview about the Habitats Directive and Natura 2000 obligations, talk about the Zilbeti court case, the appeal, and some of the questions we had in this case. Next slide, please. Next one. Yeah. Well, it's important. Well, the slide before, please. But anyway, I can talk about this. It's important to know about the Natura 2000 network. Besides the introduction and it, are areas of great value for the protection and conservation of biodiversity in Europe, identified with technical and scientific criteria. This is important. We are dealing not only with law, we are only dealing with a lot of biology and scientific criteria that are inside of the Habitats Directive. It was created to address the serious loss of biodiversity in the European Union, and they realize of the need to act at EU level, not every country by itself. The legal mechanisms are stricter than in other areas for assessment, the protection, because the aim is to preserve a common natural heritage, which is increasingly threatened. The Natura 2000 network was created in 1992 through the Habitats Directive that integrate the SPAs from the Birds Directive that need to be strengthened and enforced in a better way. Just some details. Natura 2000 is the most important network of protected areas in the world. Next slide, please. Well, as I said, this consists of sites of community importance, SCAs, that to be designated later as special areas of conservation in accordance with the Habitats Directive, and special protection areas for birds, the SPAs. They include the species of Annex 1 and migratory birds of the Bird Directive, and habitats and species of Annex 1 and 2 of the Habitats Directive. It's important to know that it's a coherent network. We are not talking about isolated protected areas. Many of them are designated because migratory spaces, and it's very important, the ecological connectivity, ecological corridors. It's important to know also that there is a global consideration on the conservation status. It's not just in each member states, is across the European Union. So it works on biogeographical and marine regions in the European Union. There are regions, they are not the borders of the countries, they are regions that share ecological characteristics in vegetation, climate, geology. And working at this level, at biogeographical level, makes it easier to conserve habitats and species with similar natural conditions in 28 countries. Well, now 27 countries. Next slide, please. The Natura 2000 obligations under Habitats Directive are not only the appropriate assessment, we are going to talk later. We have the first obligation, declaration, designation of protected areas under the two directives, birds and habitats. Next, there is an obligation on adopt conservation measures and where appropriate management plans, not in all the countries, there are differences. We have also the obligation to prevent, to avoid deterioration and significant disturbance of habitats and species in Article 6.2. And the appropriate assessment of plans and projects that may affect these areas. in Articles 6.3 and 6.4 that we will explain in detail. When necessary, also ecological corridors, connectivity areas, and other obligations of research monitoring. We have here positive and proactive measures, the ones of Article 6.1, and preventive measures, the 6.2, 6.3, and 6.4, to avoid this deterioration, alteration, or appreciable impact on Natura 2000 sites. Article 6.1, conservation measures, applies only to SACs. SPAs have also this obligation under Birdlife Directive. When an SCA has been approved in the list by the Commission, there's obligations applied Article 6.2, 6.3, and 6.4. Next slide, please. Well, we have some systemic country breaches. In this case, for instance, I'm going to talk about Spain. We have had some groups or core rulings and judgments about the Birds and Habitats Directives and Natura 2000. First of all, we have the designation of sites that was following some court cases of the Court of Justice of the European Union, was the beginning. Next, we have a group of court cases and judgments about CIS2, CIS3, mainly about plan of projects and about the appropriate assessment, the duration, not so much about CIS4, about the exception, because mainly the projects stop in the moment they say that there was not a significant affection or there was not adverse effects on the integrity of the site. So the authorities avoid to apply 6.4, although in more the case they should. At the end, we have a second other group of cases because the management plans were very light on time over the 6 years deadline. Some of the last judgments are dealing with appropriate conservation objectives and conservation measures that have to be set in these management plans. Next slide, please. Well, going into the Zilbeti court case with details. Next slide. Some background about the protected site and the case. This site was proposed as SCI Monte Alduire Forest, Alduire Forest, by the Autonomous Region of Navarra in Spain. In Spain are the autonomous communities or regions the competence to propose and management these sites. After the European Commission approved the list of SCIs in decisions, this site belongs to the Atlantic and Alpine region. It's located in both biogeographical regions, so was in both lists approved by the Commission. Just in 2005 was declared as, was declared as SAC, and a management plan was approved. It was the first one in Spain as we declared as SAC and to have a management plan in force. This site included endangered species, white-backed woodpecker, that is a very endangered species in Spain, and this site has the second population in importance. Priority habitats and species, alders, European mink, strict protected species, Eprinian desman, coleopteras, migratory birds, bats, lots of stems. Next slide, please. The site management plans establish the objectives and conservation measures that are key to the application of the Article 6.3 of Habitats Directive, and establish some key elements, habitats and species, for which they had to be set conservation objectives. This is an example. These are the key elements of the site. I put here as an example some of the final objectives, because it had a lot of importance on this case and how the court was convinced of the breach of Article 6.3. For instance, habitats, beachwoods. We have as objectives in the management plan to maintain at least in the current state the area and conservation status of habitats and conservation interests. For beechwood, to harmonize the execution of the different activities, to avoid the erosion, loss of ground, and to guarantee the conditions of naturalness of the forest. And for the picket community, wood pickers, maintain at least the densities of white of these birds, estimated in 1993 in the studies in this group of mountains. They were the conservation objectives, the final conservation objectives for these key elements that the card has to deal later with. Next slide, please. This is the project. We can see it was just inside of the protected site. It's in purple. It's Lewa Alcotada mine, very close to the village of Zilbeti. So this case is called Zilbeti case, and it was close to another mine of the same company that was 3 kilometers away outside of the protected area. And the justification was just to get more mineral, magnesite mineral to process in the factory the company had in a near village, because they say that if they didn't did this new mine in Zilbeti, the factory will have to close and lots of jobs could be lost in the area. Some things. The project was not only the mine, were also a tunnel, chains on roads, and connections. Next slide, please. The impacts of this open mine. Well, the main one was at the beginning the logging. Sorry, the logging of 50,000 beech trees. Then a mining hall of 21 stories, tunnel, tracks, platforms, accesses, modification of roads and bridges. There were to extract 1,800,000 tons man exceed by year with blasting, explosions, excavations, and with an increased heavy traffic noise, dust, diversion and destruction of streams and water tables. It was not only the mine, but was also the transport of the mineral and all the transformation of a very natural area in a mine. Next one, please. So the environmental impact statement of the developer said that no significant effects have been identified on any of the 11 key elements of the protected site, and that the project will not significantly affect the integrity of this Monte Alduiri protected site. Even said that adverse effects were partial and temporary, and the final rehabilitation of the soil morphology and vegetation ensures environmental conditions very similar to the pre-operational ones, improving even in some aspects related to biodiversity. That was like a joke, because this is an example. This mine is the neighbor mine, the same company, and this was going to happen to this area. And they say that there was not any affection to the integrity. Next one, please. So the environmental impact statement and permit issued by the authority first had some unfavorable reports of the Biodiversity Conservation Service. They say that something very obvious, that the mine will affect 8 key elements of the SAC, would imply the failure to meet 10 of the 16 final conservation objectives that were allowed. And so it threatens the integrity of the sites, the maintenance of its ecological functions under Article 6.3 of Habitats Directive. So it was the reports of the internal reports of the own authority. After this, one very short report states the same day of that the environmental impact statement was used, that corrective, compensatory, and monitoring measures are included, and they ensure that activity does not significantly impact on the key elements of the space. So, just with this, the region government issued a favorable environmental impact statement and approved the project. So, Birdlife and Neighbors Association challenged the environmental impact statement and permit to the Navarra High Court of Justice after the use of the permit. Next one, please. For breach of Article 6 Habitats Directive. This article is like a small universe in itself. It has complete guides only for and lots of court cases and court rulings. Every sentence has been studied. So is any plan or project likely to have a significant effect on a Natura 2000 site, either individually or in combination with other, shall be subject to an appropriate assessment of its implications for the site in view of the site's conservation objectives. After the conclusions of this assessment, authorities shall agree to the plan or project only after having ascertained that it will not adversely affect the integrity of the site. Okay, this is what Article 3 says. So this requires a stepwise procedure before a development can go ahead. First, authorities must consider where there are any likely significant effects, like a pre-assessment stage of screening. Many projects stop here. They say, no, there are not going to be significant effects. It's important to know that here, to say that you have or not have these significant effects, you can apply, for instance, mitigation measures. If you have to apply mitigation measures to say that there are no likely significant effects, you have to carry out the next steps, the appropriate assessment. And so the appropriate assessment is the second step, should be made of the implications for the site and its conservation objectives. It's important because it's different to other assessment under the environmental impact statement directive or other kind of assessments. Only where there is this certainty that no adverse effects on the integrity of the site can agree. And if there is a negative assessment and they want to go on with the plan or project, they have to apply the systems of Article 6.4. The Court of Justice for the European Union makes it clear that this test must be taken sequentially. You can jump to one step to others without the intermediate ones. And member states cannot take into account, for instance, compensation measures in order to rule out legally significant effect or adverse effects on the integrity and carrying out the other test. Next one, please. So in the Zilbeti's case, the claim and grounds were that the authorities failed to properly apply Article 6.3 of Habitats Directive in considering impacts of the project on the protected site, and claim breaches of Article 6.4 and 6.2 also, and the key elements of the case were the appropriate assessment, integrity of the site, the role of preventive mitigation and compensatory measures, and the precautionary principle in authorization. Next slide, please. Here we have just an overview of the screening and appropriate assessment process. Well, as I said, the appropriate assessment has to be done not with certainty but likelihood of significant effects with a mere probability. And when we are inside of the appropriate assessment, we have also some clear rules. Assess in view the site's conservation objectives, cumulative and in combination effects, and even very important, the key we have is about the mitigation measures. Can the negative impacts be removed through mitigation measures? Yes, no. Because if it can be removed, the authorization may be granted, but if not, authorization must not be granted. And here is usually the discussion. If the mitigation measures are enough. And many times, as in this case, the problem is that they are not really mitigation measures, they are compensation measures because the adverse effects cannot be avoided by it, and so they jump to compensation measures. Next slide, please. So the appropriate assessment has to be, is not any assessment, indeed documented, scientifically motivated, taking into account these conservation objectives, and also the vulnerability of the site has to be up-to-date information. It's not merely a formal administrative act. Economic and social interests cannot be weighed in this stage. It can happen in other assessment, but not in the appropriate assessment of Habitats Directive. There's a need also to evaluate plan or projects even outside Natura 2000 that may affect. It's carried out often inside environmental impact assessment or SEA processes, but has to take in account the specificities of the Habitats Directive. Next slide, please. Sorry. So the integrity of the site relates to the site's conservation objectives. It relates to all the habitats types or species for which the site has been designated, with significant presence in the standard data form. Is very important, this standard data form of every site. If just one of the species habitats is significantly affected, taking into account the site's conservation objectives, then the site integrity is necessarily adversely affected. Sometimes we don't have management plans, or we didn't have conservation objectives were not set. In this case, the appropriate assessment must assume as a minimum that the objective is non-deterioration of the site. Next slide, please. So in the Zilbeti ruling, the integrity of the site question was about the unfavorable reports, the failure to meet the final conservation objectives, corrective compensatory and monitoring measures. And we provide also 5 scientific and expert reports about the impossibility of correction or mitigation of these affections. Next slide, please. One moment. So the co-ruling said that given this evidence, there is no other conclusion. The project affects the integrity of the site, and the environmental impact estimate should not have been formulated in a favorable way, and it was a breach of Article 63 of Habitats Directive. So the RATSUD was estimated and the project annulled by the Court of Justice of Navarra. Next slide, please. The judgment also talks about the percentage of the protected site affected and about site integrity. This is an argument frequently and often used by the competent authorities, that the space is minimum with respect to all the surface of the protected sites. Yes, it's minimum. In this case, the code recognizes it, but told that what is relevant is that the effect is on the integrity of on the SCA, which is made of the entire surface area, and use the analogy like a living body in which the effect of one part affects the whole. Well, the question here is that the adverse effects refers to the conservation objectives, not the surface. And in this case, we have that, for instance, one of the main conservation objectives, maintain at least the white-wicked big population, that were 12 couples. The project affected 4 couples. So we had a 33% of one of the main conservation objectives adversely affected. Also, the objective of maintain at least in the current state, the beachwood was affected. And clearly, this argument was not applicable here. Next slide, please. Sorry, I had some problems with my voice. So mitigation and compensatory measures in Article 6. The question here was that they said many times, as I said before, they mix mitigation measures and compensatory measures are not the same. Mitigation measures aim to avoid or reduce impacts or prevent they occur. Compensatory measures are intended to compensate damage that you had said is going to occur. So the compensatory measures can only be considered under Article 6.4. And when you set compensatory measures and say that there's no an adverse effect on the integrity of that site, this is wrong. If you set compensatory measures, you are accepting that there's going to be an adverse effect on the integrity of the site. And so you don't have to authorize, or you have to do it under Article 6.4 Habitats Directive system of derogation. And also very important, because sometimes we have mitigation measures are, for instance, we are going to mark the trees we are going to cut just to be sure that we cut the correct ones. Or we are going to do the works only in a spring. That is a legal obligation to not affect the breeding season of the species. So each mitigation measure must be described in detail with an explanation based on scientific evidence how it will eliminate or reduce the adverse impacts. It's just not to put a list of standard mitigation measures. It had to each one of them has to be detailed and explained. Next one, please. In this Zilbeti case, the environmental impact statement proposed measures to compensate for the loss of habitat of the white-beaked woodpecker. They say that to improve the habitat around the mine and exit of the tunnel, they would apply measures that improve the forestry management. They will leave areas of dead wood that was good for the species. And they say that this guarantees the integrity of the site. But on the contrary, as I said, established compensatory measures shows that the site integrity was going to be adversely affected. Anyway, they were mandatory management measures that had to be obligatorily applied in the protected site, even without the project. And even more, the experts warned about an ecological sinkhole effect. That was that if you create a suitable habitat close to a very perturbed area as a mine, it's apparently good for the survival of the species. Maybe they said there, but it's very bad for the production, and because of the stress, noise, and everything, and it can affect the viability of the space. It can have a contrary impact. Well, on the mitigation measure, as I said, the standard ones. Next one, please. In this case, the precautionary principle is integrated in the Article 6.3 of Habitats Directive and in the authorization criteria. In this case, the court has no doubts. The project affects integrity and cannot be authorized. But in other case, if doubts remains for authorities, for courts, for judges about the absence of adverse effects of the integrity of the site, the competent authority will have to refuse authorization of the judge has to declare that it was in breach of Article 6.3. The onus is therefore on demonstrating the absence of adverse effects for the developer rather than their presence. This reflects the precautionary principle. You don't have to give a lot of evidence. It's good to do it mainly to try to demonstrate the doubt. Sometimes, even if you cannot give evidence about the adverse effects, just the doubt and the absence of certainty could be enough to not give the permit. Next one, please. So, in this case, the derogation of Article 6.4 of Habitats Directive cannot be applied if the provisions of Article 6.3 have not been applied, it has been breached. So, in this case, the Zilbeti ruling said that it was not infringed because it was not applied, that the defendant claimed that there was not effect on the integrity of the site and they did not use the exception. But well, this is true, but it's true also that the defendants applied compensatory measures and claimed in some times of the processing overriding public interest that are parts of Article 6.4. No alternative solutions, imperative reasons overriding public interest, and compensation. All of them has to be applied, and in this order is important. In this case, the court considered that Article 6.2 was infringed. In this case, said that it was linked to the infringement of Article 6.3. 6.2, the obligation to avoid deterioration. Next one, please. After this ruling, next one, please. The mining company and some municipalities appealed to the Supreme Court in Spain, which fully confirmed their first ruling that annulled the mining project. In this case, what the Supreme Court says that about the talk about the precautionary principle, confirm that after assessment of the evidence, that talk about the 8 of the 10 key elements would be affected, and the final objectives were going to be affected in a high proportion also. And talk about the percentage on the surface area. It said that it's not decisive. What is relevant is that the effect is on the integrity of the protected site, which consists of its entire surface area. Next slide, please. We have also here the question of interim measures. I remember it was in Christmas, just when the permit was given, they start some works that were not strictly related to the mine, just to the access. Well, they start. So, next slide, please. We asked for an interim measure to the court. In the Spanish law, the authorizations are immediately enforceable unless a court annuls them. The works can go ahead, so you have to ask for an interim injunction, as many countries, to stop the works while the process is underway. So in this case, Article 6.3 and 6.4 Habitats Directive some specificities and difference. I think, and we are with that, they have to be taken in account in the waiving up of the interest at stake, in the periculum in mora, the danger in delay, that are the elements the national courts apply for interim measures. Famous bonis juris, apparency of right law, and also in the request for bond and sureties that cannot avoid these interim measures. It's very, very important to have in account that national judge is not only a warrantor of community law when he acts in the main proceedings, but also as an interim judge. A national judge falls under the competent national authorities that Article 6.3 of Habitats Directive establishes. Next one, please. So in this case, the interim injunction was rejected at the beginning. The High Court of Navarra considered that although there was danger in the line, they recognized the adverse effects on the site if the work starts. The weighting of the interest at the state was still towards the administrations, because they say that a lot of municipalities, not all, of the area, opposed to the precautionary measure. It was, I think, that not a good decision. However, it didn't take into account that they recognize the adverse effects, but even in case of doubt, at this early stage of the proceeding, even in case of doubt or notification of certainty of damage, you cannot, the project cannot be authorized, not execute, or the works go ahead. It has to be applied, the precautionary principle, in a strict way in this kind of cases. And Article 6.4 of the Habitats Directive includes the waiving of interest in a regulated way and other requirements for authorization and starting works. and they were not taken into account in this case. In this case, some mining works were started, but not the logging of mineral works. It was by the mining company because there was a very important public outcry and media attention on the case. Next slide, please. In this case, for instance, this is a part of the forest. The neighbors paint with the painter of the Spanish painter Picasso, the Guernica. Just to give attention to the fact that the forest, this part of the forest, was going to be destroyed at this village in the painting was destroyed by bombings. And well, the works didn't start, but it's important to know that if the company would have done it, maybe the damage will be irreversible now. Next slide, please. We had also, just to finish, some interaction with other European Union procedures here. Next slide, please. As I said, we challenged it, several challenged it in court. But when the court proceeding was started, at the same time there was a question to the European Parliament by a citizen about the breach of environmental impact assessment directive on this Zilbeti case. So the Commission answered to Parliament because there was not almost information on this petition, and the information the Commission has and answered in a quick way that at least formally an environmental impact assessment has been carried out. So the defendant appealed to court replied to our lawsuit that a commission did not find a breach of the law in this case and had rejected a complaint. That was not true. There was not a complaint. It was a petition to the European Parliament, but we had a problem here because it looks like a commission has said this. So next slide, please. In this case, the NGOs submit a formal complaint to the Commission for breaching of Habitats Directive, in this case. Usually we didn't do because the system of the Commission is that if the case is under national court procedure, the complaint doesn't used to go ahead, not in all the cases, but is the ordinary actuation. What we did in this case is present as evidence to the court the Commission's letter registering the complaint and opening the EU pilot, and explain to the court the difference between a complaint and a parliamentary question. Next slide, please. Any citizens can just direct a petition to the European Parliament on any matter, as this citizen did with a very good word. And Commission that attend all the meetings shall reply orally or in written, but it used to be very, very quick answers that with not a lot of information, just the one of the petition. Next slide, please. Which is quite different of our EU infringement procedure. The infringement procedure has regulated phases, an initial phase with the complaints, with an early resolution stage, a structural dialogue between the Commission and Member States, and a formal procedure with a pre-litigation procedure, a formal notice, and even a litigation procedure with a possible referring to the Court of Justice. We had to explain this to the National Court and said that there was not any rejection of a complaint in this case. Next slide, please. So it was in this case, well, Commission closed the complaint 2 years later because there was a case open before national courts. It's the practice of the commissions to close files on which no infringement proceedings have been initiated, pending decisions taken by national courts. But in this case, it was enough to show to the national court that there was not a rejection in the moment that was more critical 2 years before. So the High Court of Navarra, as I said, annulled the mine's authorization for reaching Article 6.3, and Supreme Court later confirmed the judgment in 2 years later. But it's important to know that you have to be very careful with other procedures open at the same time, and to be very aware of the ones that other people can open, even if you don't know or you are not implied, because it can seriously affect an internal court proceeding. Next one, please. I think, yes, I'm finished here. Thank you.
Unmuted.
Can you mute yourself, Soledad?
Yeah.
Okay, I'm sorry about the echoing. It was caused by both of us being unmuted at the same time, and I hope it's not happening now. So we've received, oh, it's not happening now. Okay, we've received a few questions, so I'm going to make these visible to everyone, and then we'll answer them orally. So I'm just going to make them visible, just a sec. This one. I'm sorry, just bear with me a second. Isn't that? Just a second. Right here, this is the first one. Okay. I'm going to go first. I'm just going to continue. So I'll go to this question from Elena, which is on access to justice. So it was more directed at me. And she asks, so the Aarhus Convention says that non-governmental organisations should promote environmental protection and meet any requirements under national law. Can you comment on the requirement to meet any requirements under national law, and does this constitute a problem as requirements on national law differ? So very quickly, yes, it does cause quite a problem. First of all, just to mention quickly that there is also Article 3.9 of the Convention, which says that these, basically, it says that these conditions should not discriminate against foreign NGOs or NGOs, you know, that have their registered office in other countries, etc. But in practice, a lot of the criteria does end up having the effect that NGOs in neighbouring countries find it very difficult to bring cases in another member state, even though they can be obviously affected by plans and projects that are taking place in a different member state. So criteria like that can be, for example, that they have to have their registered office in the member state where they are, where the project is taking place. So that would be obviously discriminatory. But there are other problematic criteria. For example, the number that certain member states should have a very large number of members, which can then obviously pose problems to much smaller organisations that don't have so many members. So that was the case in a case that came before the Court of Justice from Sweden called Djurgården, which I will try to, the reference is in our guide to access to justice, which we'll give you the details for. And there it was a Swedish law that said that organisations to be recognised had to have 2,000 members, which was completely disproportionate when you looked at the NGOs active in Sweden. It meant that very, very few could get into the courts. So the Court of Justice said really clearly that that really barred a whole the vast majority of NGOs in Sweden from going to court, and therefore it was clearly against the convention, or was actually, I think it was the EIA directive, which kind of implements that part of the convention into EU law. But 2,000 members is quite extreme. So there are other member states that have, requirements to have, smaller numbers of members, but that are still significant enough to pose a problem in terms of accessing courts for small NGOs. And we still don't really have a very good idea as to what is acceptable or not in terms of the number of members that you ask for. There are also criteria in terms of, like, for example, the length of time that an NGO has been active. That can also be quite problematic, especially for organisations that are set up kind of ad hoc to fight a specific problem. And then there are also criteria on financial, financial standing of certain NGOs to ensure that they can pay their costs, etc., etc. But these can also be quite problematic. And of course, the fact that they differ across the member states, is also. It can also be a problem, although we have to recognise that member states do have discretion in this area as well. So I hope that answers your question. I'm going to mute myself, and I'm going to let Soledad answer the question that was about, and I'm sorry, I'm trying to get through these questions, but it's quite, I'm doing it on my own. So there was a question on Article 16 and trophy hunting, and I'll mute myself and let Soledad perhaps answer that one, and that'll give me a chance to kind of get through the other questions.
Okay, thank you, Anne. Well, first, I have also one question about France. Has not produced a priority action framework which, in accordance with the objectives of the Habitats Directive, must enable the government to plan EU funds financially to achieve the conservation objectives for Natura 2000 sites. And the question is if this absence of this priority action framework could be a breach of the Habitats Directive and could be taken to court. Well, I can't give a specific answer to it, but it would be linked obviously to Article 6.1 of Habitats Directive and the obligation and establish appropriate and the necessary conservation measures, and obviously the finance of these measures is a very important issue linked to this, because there's no, if you set measures and objectives and you don't give the elements and all the tools to apply them, it's like you are not establishing them. So, about the question, let me see. Well, before the one of the legal mechanisms provided in the Habitats Directive is suitable for protection of priority habitats and species outside Natura 2000 areas, we have Article 12 for Habitats Directive for animal species listed in Annex 4. In this case, I think should be the legal provision to apply outside Natura 2000 areas. And also very important to have always in account that even species with a wide range or that can move between Natura 2000 areas, ecological corridors, connectivity areas between species, some projects that are located in these connectivity areas, strictly speaking, outside Natura 2000 areas, can have adverse effects on Natura 2000 areas because they cut the connection. And so it could be possible also to use arguments of Article 6.3 and 6.4 in this case. So, what's the Commission position with regards to admitting or rejecting a complaint once the national case in a state has already been judged by the national court, not during process? Well, I don't know many cases. They are not about nature or environmental issues that I know. The fact is that national judge is a judge of, that has the obligation of apply the European Union law in a correct way. So theoretically, after a national court case that has not appeal and that sets a very bad interpretation of the European Union law, maybe you can use this argument to a complaint to the Commission. It could not be easier, but if you can demonstrate that the European Union law has been breached by a court judgment, I think that it would be possible, difficult but possible, and I don't know many cases for this, but I think could be possible. Sorry, I don't see the one of the beers, the question. I'm just going to answer the ones I have here and look for it later. Does the Supreme Court in Spain get into in substantive details of the case brought before it, or does it just deal only with the interpretation of the law? In this case, we have an appeal with restrictions in Spain to the Supreme Court. It doesn't go into the evidence or proof, only it's very, very rational, the first judgment on the valoration of the evidence. It dealt only with law, but confirmed first the judgment and just the assessment that the first court did in this case about that. One thing that was in every case we had in Spain and after has been that is the surface, the integrity of the sites relate to the percentage of surface affected. That is not right, and it was important that the Supreme Court said that integrity of the site was linked to conservation objectives independently of the percentage of the area affected. That is the right answer, of course, but we have these discussions and has been keeping happening later. More questions here. Oh, sorry. One moment, as I'm trying to answer that in the order. There's a lot more. Yes, despair. Joan Andrade from Spain. In Portugal, currently several management plans forests are in public consultation, but they completely let out bird species, and most of them overlap with SPAs. The question is if this is acceptable or normal, or if we can push for threatened bird species to be considered in management plans. Well, in this case, if they are SAC designated for other species different than birds, I find it difficult if you don't join it with the SPA measures, because the question is that you have the states have obligation to establish conservation objectives and conservation measures for the species with significant presence in the site. You can find it in the standard data form. And in SAC or habitats and species can be birds in some cases, like in this Zilbeti case, the management plan includes birds. But if you are going to challenge SAC only for the birds, maybe it's difficult because you have to do it for the conservation measures on the species for which the site was designated. That may be not birds in this case, even if the standard data form mentioned them in one of the annex. You have to be to have this in mind. More questions about this other one here for asset protection or space. There's a question about Romania that I don't understand. Can a member state seek EU protection in respect of these national protected areas, not Natura 2000? There is currently such a law recently enforced, looking to modify the limits of such areas. Sorry, I don't understand. I don't understand well this question. I know it's linked to the qualification or the classification of sites that has. They have also a strict requisites under Habitats Directive. The brown bears. Yeah. Certain populations are strictly protected. Brown bears and gray wolves, keeping and killing these animals, in your opinion, should trophy hunting be excluded from being subject to any derogations? Well, it's a tricky question because the system is the one it is. We have a system of derogations, and in this case, it depends of the inclusion of these species in national lists, as you said, and the populations strictly protected in some areas. Maybe they are not in other areas, but maybe they are connected, as I said before. I'm not sure about this question and this answer because I don't understand it also. I think that if you have the legal grounds, you can challenge trophy hunting of deers in national courts, but I will have to have more information to give an accurate answer to this. I think there was another question of access to justice, maybe before this.
Yeah, there's a question on access to justice for individuals. Let me just try and find it again. Sorry, I'm just frantically scrolling through these questions. I did see it from Alexander. So extending from NGOs, how does access to justice extend to individuals who may not have an NGO to support them yet? So yeah, this is a really, this is a very large question. So again, I'm going to invite you maybe to get in touch with me and I can ask some more questions because it certainly depends on the case and what article of the Aarhus Convention applies and potentially what EU directive applies. For example, if it's something for which there is an EIA that's necessary or where an individual can participate in the decision-making procedure leading up to the decision, and that enhances their chances of being able to challenge the decision, etc. And to be honest, all of these rules vary quite a lot depending on what member state you're in. So again, that will make a very big difference. There are also other considerations apart from just having the legal right to get to court. There's also considerations in terms of the costs that it would imply for an individual. For example, in the UK and Ireland, you can have very easy access to the courts, not particularly difficult to get into court, but the costs are such that individuals sometimes have to mortgage their house to bring a case, which is obviously prohibitively expensive, which is against the convention should protect against that, but in reality, it doesn't really for individuals that don't have vast sums of money at hand. So yes, there are some member states where some hurdles are easy to bypass, but there are others, and then other member states where the problems are different. So really wide question, and I would invite you to maybe get in touch with me to discuss it in more detail. Okay, and then I'm just going to have a quick look at the questions that we haven't answered. I think there's quite a lot. Oh, yes, go on.
There's one interesting question I didn't see before. That's about hydropower dams. The question is, how might the Habitats Directive be adapted to more effectively manage and mitigate the environmental impact of small hydropower dams that are not currently covered under the law that requires environmental impact statement? Well, this question is that I think doesn't really to be adapted because you have to be able to apply the Habitats Directive even if the law doesn't require some ordinary environmental impact assessment. In this case, it's independent. You have to carry out the appropriate assessment and the screening of the Habitats Directive. If you have these habitats and species, even if the small heliport dam is not inside Natura 2000, maybe it can have effects in a Natura 2000 site downstream, or you have to take in account all the species that rivers are very, very important ecological corridors, and usually the change of the water regime, the environmental flow for this kind of projects can be enough to have a significant adverse effects in Natura 2000 sites inside or outside these places. So I think that you have to go ahead with the Habitats Directive. Maybe you can use also in some cases the Article 4.7 of the Water Framework Directive about the deterioration of the water mass that are in good state, but it's independent. You can use Habitats Directive, I think, for this.
Yeah, I think we've almost answered all the questions. If we haven't, I'm really sorry. It's just that we're kind of, because we're located in different offices, it's quite difficult for us to communicate between each other, etc. But we're doing our best, and you can always get in touch if your question wasn't answered. So I do believe that we'll send an email to everyone that was registered, providing the slides, and we always place on our website, particularly the website of the project, which is Access to Justice for a Greener Europe, the YouTube recording also of all of these presentations, so you can go back and have a look and fast forward the bits that are boring, etc. But anyway, thanks very much for your attention, and I think that pretty much brings us to the end of the webinar. I'll just check if Soledad has any last comments. Nope, I don't think so.
No, that's my part. Thank you very much to the assistants.
So thank you very much, and have a really nice afternoon.